All right, so let's go ahead and get you guys started. So I am Victoria, for those of you that I have not had a chance to work with yet. I am one of the estate planning attorneys with the Koppenberger Law Firm. I have been with the firm for just over 4 years now and am extremely excited to get to work with each and every one of you. Now, in addition to myself, we have an incredible team of attorneys. So one of the reasons that we are able to help as many clients as we are for as many years as we have been is because of this team of attorneys. But what this team also is going to show you is that we do more than just estate planning. So today is going to focus on what is an estate plan, how to set one up, and how to make sure you are protected in the event of incapacity or death. But unfortunately, we do know that at some point everyone does pass away. And so we also have an estate administration department. The administration department is there to essentially help you or whoever is going to be taking over after you have passed to make sure everything is settled, that the family has the resources and support that they need, and that there's nothing that's going to be outstanding that can cause issues in the future. We also have a business and tax department, and our business and tax department is there so that if you have any questions as far as what your business needs to do or know about formation, about taxes relating to your business, relating to you personally, or other things, we can also handle those in-house also. Now, we could not do what we do as attorneys without this amazing staff, though, to support us. So this staff really is the heart of why we are able to help so many clients and be so responsive and be able to do these education events to stay in contact with you. These are the people that make sure that the wheels keep running, that we are able to have the support we need to serve you to the best of our abilities. And then we also have offices all throughout the state. And so if you are physically not near one of these, the good news is we also can do meetings over Zoom. But if you are physically near these offices, we would love to see you in person if you are comfortable. The other nice thing is that if you start, let's say, in our San Jose area, and then you end up moving down to Temecula, we can very likely continue helping you in person if that is what you would desire. Now, we are going to cover quite a bit of information in a relatively short amount of time. So again, if you have any questions, feel free to throw them in the chat or the Q&A portion of this. But we also have these recorded, and so they will be going out to you at the end once we have it all edited and put up on our website. And we have other resources on our YouTube channel. So if you need more information, if you want to get a refresher on what this all talks about, please feel free to do so. And then because you are attending this webinar, you are also entitled to a free consultation. So with that consultation, that gives you the chance to meet with us one-on-one and ask your specific questions and make sure that we are addressing your specific needs. Now, most people are extremely excited when summer is here. They're excited, especially if they're a younger, I'll say kid, they're really excited. And parents often are as well, because it means you get to make memories and everything else. It's also a great time to be outside, to be in your garden, to travel, and so there's a lot of good that comes with summer. Unfortunately, though, with summer, there is also the other side of it. More people are out, more people are on the roads, there's more people just physically around you. And as a result of being around people, unfortunately, that can lead to accidents and things happening that are not to your benefit. It also is truly going to get hotter. I don't know if you've looked at the weather app, but at least in San Jose, we're going to be hitting the mid to high 80s here in just a couple days or about a week. And so all of a sudden, things like heat exhaustion, even unfortunately, you're in the pool, drowning incidents, things that are not positive do occur. And so the reason we bring this up is because, as exciting as summer is, we want to make sure that you are protected to the best of our abilities going into summer. Everything we do here at Koppenberger is focused on pre-planning, making sure that if the worst case scenario happened, it's not made even more worse by not having a plan in place, but instead that either you are taken care of or your family is able to take care of things in the unfortunate event that you actually pass away. So how do we do that? Well, we are able to create an all-inclusive protective estate plan. Now, for some people, you are going to, when we're talking about your estate plan, need every document that you see on this screen. In other cases, you only need one or two of them. So let's break down which ones you absolutely need and which ones you might need. So first and foremost, if you are over the age of 18, or you have children or other loved ones who are over the age of 18, you absolutely are going to need an advanced healthcare directive. This is the document that would give the doctors and nurses the authority to speak with someone who can make decisions and act on your behalf. If you, for whatever the reason, are rushed into the hospital and cannot give verbal permission to someone, it has to be in writing. If it is not either given verbally or in writing, that permission to make your choices, legally, the doctors and nurses cannot talk to anyone. That means they couldn't legally talk to your spouse, your children, your parents. They do not have that authority. Now, some doctors will ignore this and they'll talk to you anyways. But any doctor who has ever been at the end of a lawsuit, take this law, which is called HIPAA, extremely seriously. And so it's a vital thing to have in place before any use or need for it occurs. The other thing it does is it answers a lot of questions for end-of-life care that oftentimes can lead the family to having either peace of mind because you've already answered those, or a lot of worry, stress, and even guilt because those questions weren't answered ahead of time. So we encourage everyone to be on the first side of that you've answered some of these questions like life support, organ donation, what you would want done as far as burial or cremation, so that your family does not have to question, guess, or feel any kind of guilt over making those decisions. So again, this not only ensures you are protected, but it also makes sure that your family has some peace of mind as they go through this phase as well. The other document you absolutely need if you are over 18 is what we call a durable power of attorney. This is the document, excuse me, where if you are incapacitated, you are giving somebody the permission, in writing again, to make decisions regarding your finances. Banks are not going to let just anyone come in off the street and say, hey, I'm her kid and I want to be able to make her financial decisions. That's what she would want. They're not going to just take you at your word. You have to have it in writing that you have that authority to manage those assets and maintain them on behalf of someone else. Again, if you're incapacitated, this is not the point that you want to be in a position where you don't have someone to take care of you. So again, this is really important to have an effect before something goes wrong, not after it's too late. Now, the next question becomes, do I need a will or do I need a trust? Everyone needs something. You need to put in effect what is going to happen with your stuff after you pass away. Otherwise, the court is going to make that determination. But some people need a will. Most people actually in California need a trust. The problem that we often see, though, is most people have heard about wills. They don't actually know what trusts are. Some of this is just because of people they've talked to, but frankly, Hollywood has had a lot to do with that. In most movies or shows, you hear about will readings and opening up the will and what did the will say was going to happen. But again, if you live in California at a minimum, you absolutely need a trust if you own real estate or if you have more than $184,000. Now, if you don't own real estate or you have less than the $184,000, you might fall into the will category. But if, again, you own real estate or you have more than the $184,000, a will is not going to be enough. The reason for that is the California state has decided that if you own a piece of property or if you have more than the $184,000, you have to have a trust. Otherwise, your estate or your assets are going to have to go through probate. Probate is a court process that basically settles things up. It makes sure that if you're owed money at the end of your life, it's paid back into the estate. If you owed money out to anyone else, those debts or obligations are paid off. And then when everything is all done, transferring title to whoever they have decided will benefit from your estate. They have a list that they work off of, and so that's why I say they decide who is going to benefit. Because probate is a legal process and it does follow state rules, it is extremely lengthy, it causes unnecessary delays, and it is extremely cost prohibitive. If you are curious what probate would cost you or your family, you can actually go to copenbarger.com to our resource tab and our probate calculator. On that tab, you will see that it asks you to put in the gross value of your estate. What that means is don't put in your equity that you own in your home. put in what you could sell that home for, not the cash you would pocket, but what the sale price would be. It's going to then spit a number at you that most likely will cause you to have a little bit of a catch breath for a second. Because generally, if you have a home that is gross value of $1 million, you're looking at a probate cost of about $46,000. So it is, like I said, extremely cost prohibitive. Not only would you have that $46,000 probate fee, you also, if your estate had a mortgage, had any other debts, had anything owed, those things have to be paid off before any distributions are made also. So you can imagine how much probate really can deplete an estate and really take away from the legacy that you could leave on and deplete assets that you worked so hard to build. So the good news is you can avoid all of that. So we talk about probate to make it really clear. Our goal here is to keep you out of court because court, frankly, is not going to be in anyone's best interest in most situations. Now, a trust is where you're basically answering all of the questions yourself that probate court would be seeking to answer. You're deciding who would manage things if you no longer could, and you're ultimately deciding who is going to benefit once you are gone. So you are called the settlor. You are the person who creates the trust and gets to set all of these terms and all of these provisions. Again, you will determine if you can no longer manage due to incapacity or death, who is going to do that on your behalf? Who's going to make sure debts are paid off and obligations are collected? Who's going to make sure that the beneficiaries you have designated ultimately get the amounts or percentages or whatever it is that you have decided? And then ultimately, who gets to benefit? Now, every family, every individual, every situation is going to vary. And so some people have a very cut and dry, very straightforward trust where it flows very, we'll say, naturally. Other people have more complicated situations. They have children who maybe manage money differently. They maybe have blended families. Maybe you don't have children, and so you're wondering, where is this money going to go? Whatever your situation is, because you get to set all the terms ahead of time, we can customize it to match what your needs are and ensure that whatever those end up being, they are going to be met and carried out once you are gone. Not going with how a court decides, but how you have set up. So you want to establish a trust really to avoid the cost and delay of probate, but there's a ton of other benefits to having a trust. One of the biggest is that you are able to plan for future generations and provide protections for those future generations. So I mentioned with some kids who maybe don't manage money very well, you can set up parameters for how that money's used, when that money is going to be given to them. Maybe they need someone else to manage it on their behalf. Maybe you're concerned about what we call outside predators, like divorce or lawsuits, taking that money away from your children. There are a lot of different protections and plans that we can establish even for them once you are gone. For most people, we also actually talk about taxes. Estate planning is not just for the uber wealthy. When we're talking about taxes, we're talking property taxes, capital gains, estate taxes, even sometimes your income taxes. And so there's a lot of tax planning that goes into pretty much every single one of our clients, because our goal not only is to keep you out of court and make sure your wishes are carried out, but also that you don't pay one more penny in taxes than is absolutely legally required. So if you have any questions on any of those things, if you want to make sure that the money stays in your pocket or your future generations' pockets, and you want to make sure there are proper protections in place to accomplish your goals, a trust is the way to go. The only downside to a trust, though, is that it only protects what it owns. And so when you establish a trust, one of the big things that we talk about is there are certain assets that need to go into the name of your trust. Now, we take care of your property. So your residence, your secondary properties, your rentals, those will actually now be titled in the name of your trust. But don't worry, your property taxes won't be touched by doing so. So you don't have to be concerned about that. We also, though, say that your checking accounts, savings accounts, and non-retirement stock accounts also need to go into the name of the trust. Now, this is something we walk our clients through numerous times. And if you already have a trust and you don't know if you've properly done it, please absolutely come and talk to us. And if you're concerned about how are you going to remember all these things I'm talking about right now, don't worry. Throughout your estate planning process, this is again something we cover numerous times. But we also know things happen, and we are giving you a lot of information, not only today, but also in your different meetings. And so we know life happens. People forget some of what we've talked about. Maybe it's been years since they've seen us and you have a new asset and you don't remember what we told you 5, 10, 20 years ago. So one of the documents we also create is a will. Now, one of the big questions is, why do I need a will if I already have a trust? This is a very different type of will than what we call a standalone will. This is one we call a pour-over will. Its main goal is to provide extra asset protection after you pass away, and says if you had forgotten or chose not to put an asset in a trust and it would otherwise be subject to probate, that big thing we want to avoid, this is the document that will tell the court, don't have it go through a full probate, send it back to my trust. Now, we do still have some court interference because we have to ask them to give the asset back. But again, it ensures that wherever you have designated it would go, that it would ultimately go. But again, this is something we don't want you to actually ever use. We never want you to have to go to court or your family to go to court even one time. So again, if you have any questions on have you properly titled assets or do you need to do anything else, please don't hesitate to come and talk to us. Now, the other part of what we do outside of your assets and making sure the money is taken care of is what about your stuff? So one of the things that we put in our trust is a power that says if you have any personal items that you want to go to someone specific, you don't need to change the trust. You don't need to come and pay your attorney more money to designate it. You can actually write a handwritten letter that says what it is, who it goes to, and just sign and date it. The stuff that we have is often overlooked because most of the time what I hear is, oh, no one wants anything. And that's often very true while you are still alive. But what we find more often than not is as soon as you pass away, people attach emotion to your things. And so these letters where you're designating items to someone who you think might be emotionally attached, you know is emotionally attached, or you just want them to have it, that can really take out a lot of the fighting that we do unfortunately see in families after someone has passed. So this can not only be a big benefit as far as knowing where your things are going to go and keeping organized, it can actually help keep families together. So if, again, you have any questions on this component, we actually have some samples that we can send you. Just let us know if that's something that you need. Now, we've talked about how to make sure you are protected and making sure that you have the documents necessary, but how do you make sure that your family is protected as life changes and the law changes? So you may be over 18, but what about your children? What about your grandchildren? As soon as they turned 18, you no longer had the legal right to make their medical decisions or manage any of their financial matters. So this is where we talk a lot of times about, as weird as it sounds, an 18th birthday gift being a healthcare directive and power of attorney that you can actually gift to them. This can be a very powerful gift. Now, they may not see it as that exciting. They may say, okay, thanks, mom, dad, I had to go see a lawyer. But this is something that if, God forbid, it has to be used, you then don't have to question, is your child going to have an advocate if something goes wrong? And if they wind up in that position, trust me, they will be thankful that these documents were in place. The other thing becomes, if they've now turned 18, do you want them to start making your decisions financially or medically? Are there roles that they should be filling where maybe when you first came to see us, they weren't ready for? So as your kids get older and mature, all of a sudden they can start filling in again as your financial managers if you can't, or the people who can make your medical decisions. So this is something to really start thinking about. Now, when we're looking at children, some people go just age-based. They say, okay, just put them in sequential order. But when we're talking about who should serve as your financial manager and medical manager, you really want to make sure that they are the person who is going to be trustworthy and dependable. Not every child is going to fit that role. Some families, none of the children fit that role. But that's more what to look at rather than who is the oldest. So if you have questions on this, if you need help navigating your family or who should be in these different roles now that they are getting older, this is something that we would love for you to come and talk to us about. And then have your families changed? So again, a lot of times when people first come to see us, they're in a very different situation and scenario than they may be in even just 5 years later. We recommend that you come and see us every 3 to 5 years, not because we expect that things are changing every 3 to 5 years, but we know that life does change. And your estate plan has its life cycle that should match yours. If you come and see us when you're a young family with minor children, we're really going to be focused on, if God forbid you passed away before those kids hit 18, who is going to protect them and carry on raising them essentially. Then they turn 18. Now we're concerned about, are they getting married? What happens if they get divorced? You're now getting older, so do we need to start focusing on more end-of-life considerations and components? And your parents might be getting older. Do we need to make sure that they're completely set up? Okay, now you have grandchildren. Now we're looking at, do my grandkids have an education fund set up? How do I make sure my legacy goes not only to my children, but also now to these grandkids? And now I am a grandparent, and end-of-life decisions are closer than we would like to think. How do I make sure that if God forbid something goes wrong tomorrow, that my family is going to be set up and that as much of the burden as I can take off their shoulders that I do? All of these phases of life, all of these different scenarios are again things that your estate plan can account for, making sure that the control remains with you and your family rather than the court and even rather than with the attorneys. And then a big question becomes, are my beneficiaries properly provided for? So again, if you have minor children, just because they turn 18 doesn't necessarily mean that you want them to inherit all of their funds if you were to pass away within their 18th year. With a minor's trust, you can actually designate that you would have someone else manage their inheritance on their behalf until they're 20, 25, 35, whatever age you would want, or ages that you would want. What we call a generation skipping trust or dynasty trust, that is dealing with your adult children. This is saying that either you want an inheritance to be managed by your child, but you don't want outside predators to get to it, like divorce, creditors, or even the IRS. Or it might be that your child can't manage their inheritance even after they've hit adulthood and what could be a mature age. And so you want to put someone not only as a manager, but also have the additional predator protection around it. This is something we talk to pretty much every client about once they have adult kids, because we know life happens. We know that as they get married or start businesses or get on the road, that liabilities can occur. And so this generation skipping trust or dynasty trust ensures that their inheritance is insulated and protected for their use and can't be taken away from them. Now, other people want to include charities. They want their grandchildren. They may have special needs children, or they have pets. I use pets as the last one because for some people, they don't either have pets or they don't want their pets included. If you're like me, where I do have my pets and I think of them very much like family, I want to make sure that if God forbid I were to pass away soon, that they would be cared for and even have financial resources left for their care, so it's not a burden for whoever would be taking them on after I was gone. So if you have kids, we'll make sure they're cared for. If you have charities or friends or other beneficiaries, we'll make sure that they're provided for. And if you have those pets, even they can be included in your plan. Now, what happens if you've had financial changes? So I mentioned your assets. When you come and see us, we'll talk about your assets. But again, life happens. And so it's good to do an update check in those 3 to 5 year reviews, making sure that if you have sold and bought a new piece of property, that new property went into the name of your trust. If you refinance, most people don't realize when you refinance, your home is actually pulled out of your trust and very rarely put back in. Did you open new accounts? Did you update beneficiaries? Have you maintained the different things that we had told you all the way back when you first started? Again, if you have any questions on these things, this is a great opportunity to come in and talk to us. And then the law changes. So part of why we advise you come in every 3 to 5 years is that the law does update every so often. We actually in estate planning are extremely fortunate that the law doesn't shift that frequently, with one caveat being the last about 3 to 4 years. In the last 3 or 4 years, we have actually seen quite a few estate planning law updates. We've had some that revolve around Medi-Cal and long-term care protection options and planning. We've had quite a bit actually regarding IRAs and how those can now be distributed to children or not distributed to children. And then Proposition 19, which greatly impacted the advantages kids had when they inherited homes as far as keeping parents' property tax bases. So if you have not been to see us since 2018, you likely have some out-of-date provisions, or you have not been talked to about different options that you now have for your documents. Again, we don't thankfully see too many legal changes, but when they occur, we want to make sure that your documents account for those changes and that you know your options under current rules. So if you have not come and talked to us again since 2018, please do not delay. We want to make sure that those documents get up to date and account for the different things that may impact you that you aren't even aware of yet. And then a huge conversation piece, unfortunately, that has to take place even for 18-year-olds, because at some point or another, either you or your loved one is likely going to face health issues. This has become such an almost epidemic at this point, with how many people are facing long-term care concerns like Alzheimer's, dementia, and even the quantity of people who are now living with and post strokes. Now, there's a lot that goes into incapacity. Half of it is making sure that if you are in the caregiver role, you know that we are a resource for you. We understand what it's like to deal with loved ones who become incapacitated, not only because of what we do and who we talk to, but for many of us in this firm, we have been in that caregiver role for at least a temporary period. So we're here for you. We get it. We are absolutely a resource, and even sometimes just a shoulder to lean on when things get tough. The other reason, though, that we bring this up is if you are looking at who will be in that caregiver role, it is really important to make sure you understand it is going to be, whether we want it to be or not, some kind of a burden. And so that goes back to making sure whoever you put in a caregiver type role, whether it's money management or helping make medical decisions, they again are trustworthy and dependable. Because if they already don't meet that criteria and then get put into a caregiver role, it is an absolute recipe for disaster. Now, one of the biggest things that's an issue with incapacity is that if you do not have a healthcare directive or financial power of attorney in place and you become incapacitated, once again, we have to go to court and ask them to appoint who would serve in those different roles. So again, answering those questions ahead of time not only makes sure that you are protected in a vulnerable state, but that your family's not stuck going to court just to get appointed to do those things that 2 simple documents could have taken care of. So please, if you do not have those in place, do not delay getting them set up. It's also really important to note that if you have an advanced healthcare directive that was done before 2004, it is no longer valid. So if you have not done one since 2004, do not delay coming and getting it done. The other thing is, with your financial powers of attorney, banks are now no longer accepting them if they are older than 5 years old. So if you have not seen us since, I'll say 2018, again, 2019, you need to come and see us and make sure we have that one up to date. That is a document that legally is still valid. But banks are cracking down on making sure that there is less or no financial fraud and elder abuse. And so they are requiring those documents be kept updated on a fairly frequent basis. What I have told every client I talk to is, while I say they are legally still valid, you are frankly going to pay any attorney a lot more money to fight with each bank to accept that old document than it would be to just keep it updated. So again, not only do you need these documents in place, you need to make sure they are current and will be accepted by the different places you need them to be. If you don't know, come and ask. Now, again, I mentioned that this is something we talk to pretty much every client about because unfortunately becoming ill and getting ill are really big concerns for seniors, and it means they're a really big concern for families. The statistics are at this point staggering. 70% of people over the age of 65 need some kind of long-term care. Sometimes it's temporary, but often due to Alzheimer's and dementia and strokes, it is extended. And what that means is not only is the length of time extended, the cost and the need for coverage has extended as well. Now, there's a lot to be said with these different plans. So if you live in California, you can throw out the word Medicaid. Medicaid is the program that applies to the 49 other states. So if you live in California, which I know most of you do, you're dealing with Medicare and Medi-Cal. Now, Medicare is an age-based program that once you hit 65, you generally are going to qualify. Medi-Cal, though, is need and financial qualification based. So it is actually a resource most people don't know they could potentially qualify for if the need arose. One of the reasons we talk about it is because the cost of these different care types and needs have increased drastically. Now, you will notice that this says cost of care in California. So if you live up in the Bay Area or even near Orange County, these are very conservative costs. A lot of our clients, when especially they're looking at long-term skilled nursing, are looking at $15,000 to $20,000 per month, which is absolutely astronomical and for many almost impossible to cover. So how do you cover it? Well, there's a lot of different ways, but the one I'm actually going to focus on today is the government under the Medi-Cal program. Most people do not think they either will or even should qualify for a government program, but the law actually changed last July. Last July. So sorry. In July of 2022, they raised the Medi-Cal limit from what was $2,000. What that meant is if you had more than $2,000 to your name, you didn't qualify for Medi-Cal. They raised it all the way up to $130,000. So for a lot of people who didn't qualify before July of last year, all of a sudden you could, or you know people who could. So that's something to absolutely keep in mind. The other thing, though, is if you are in an emergent situation where you are already looking at those long-term care costs, we actually have what we call a Medi-Cal plan or Medi-Cal trust that allows you to protect your assets and qualify for Medi-Cal. What that means is you don't have to spend everything down or give it all away. It can stay there as a supplementary resource so that you don't just lose everything or your spouse doesn't lose everything. It allows you to have significantly more options for, frankly, a program you've already paid into if you've ever paid taxes. That option to be able to preserve your assets really, it is a benefit I can't even fully put into words. So if you know anyone who is in a situation where they're looking at the reality of long-term skilled nursing costs, have them come in and talk to us. Now, again, I mentioned that the phase has shifted as far as it going up to 130,000. There is a phase 2 that is being talked about, I'll say almost threatened, for January 1st of next year. It has not been implemented yet, but it actually would eliminate limits is what they are saying. So this could have a groundbreaking change for how many people could qualify for Medi-Cal. We're keeping an eye on what that next phase is going to look like, but if you have any questions, please come in and talk to us. Ultimately, for everything that we do, not only for long-term skilled nursing, but any estate planning is going to focus on preventative planning. Planning ahead allows you to have options and allows you to have choices that many other people actually do not have if they don't work with a qualified estate planning attorney. There are plenty of attorneys out there and just people who believe that they can set up an estate plan for you. But unless they are a qualified person who does this day in and day out and has some tax background, the odds are that you are not going to have a proper plan in place that provides for all of these different choices and options that are actually available to you. So again, if you have any questions, you again get a free consultation for watching this webinar, so do not hesitate to come in and talk to us. Now, one of the biggest things that we talk about is how to leave a lasting legacy. When we're looking at every one of our clients, we know that they have some kind of a legacy to leave, whether that is financial or emotional. Every single person that we talk to has done something in their life that is worth passing on to future generations. So for some people, it's a financial legacy. They've built an estate where they want to make sure that they can pass it on to future generations, to charities, to family, to even friends, their pets, whoever that may be. And there are a variety of ways that that can be done, not only with your estate plan, but also with your CPA, a financial advisor, even an insurance provider to make sure that you are protected and your assets are. If you don't have any of those people in your life or you're looking for recommendations, we're a great place to start because we have vetted quite a few qualified professionals to make sure that your needs can be met beyond just estate planning. And then what about the emotional legacy? For many people, they also want to leave an emotional legacy, but they don't know where to start. So we are happy to talk to you and sit down with you and go through how do you leave a legacy beyond just the money? For me, my grandma was able to leave her legacy in the form of her recipes. Everything that that woman did had to do with cooking, and she was darn good at it. Or I should say, had to do with food. So she left me multiple boxes of recipes. And actually just last night, I was able to make one and reminisce with my mom about how it was when grandma used to make that same recipe and how amazing it is that we still get to do that. And that recipe has her handwriting all over it. So every time I pull it out, it feels like there's a part of her with me. These are the things that often people forget about when they're talking about estate planning. But again, we know it's a big part of you. It's a big part of your family. It's a big part of what makes people themselves. So if, again, you have questions on this component, don't hesitate to come in and talk to us, even if it's just about this. So as I mentioned, we covered quite a bit in a pretty short amount of time. So if you have any other questions, if you need more case-by-case specific things answered, as I mentioned a few times now, you do get a free consultation with this webinar. If you have questions, please feel free to throw them in the chat in the Q&A because I'll hang out for a minute at the end. But really what we're focused on with estate planning is, again, making sure that you know which documents you need, what can flag the need for a change, but ultimately making sure you plan when you can to not only ensure you remain protected, but to avoid unnecessary legal situations and to remove stress and frustration off of your family or loved ones wherever possible. So we have been around for quite a while. And so what that means is we have seen a lot. And I have been trained by some of the best attorneys in the state on how to make sure that our clients' needs are met. Not every situation is going to be simple. Not every situation is going to feel like it has an easy solution, but I promise you your estate plan can help answer those questions and concerns that you have and make sure that you have peace of mind knowing no matter how complicated the situation may be, that things will be taken care of even after you are gone. Making sure though that you keep everything up to date and reviewed is a huge part of what we talk about. And so coming in and reviewing that again every 3 to 5 years is going to make a huge difference. Let's see. I had a quick question of explaining again that Medi-Cal went from 2,000 to 130. So what that meant is before July of last year, if you had a primary residence and $2,000 and had a long-term skilled nursing need, you would not have qualified for Medi-Cal. So you would have been forced to either pay out of pocket, have some other way to pay for it. Now, though, because they've raised the limit to 130,000, you can have your primary residence and up to that 130,000 and actually still qualify for Medi-Cal. So for many people that have a long-term skilled nursing need or any kind of Medi-Cal coverage need, they are able to then qualify for Medi-Cal. If you have over that 130,000, you cannot qualify for Medi-Cal without additional planning. So if you have more than the 130, then it's going to be important that you come in and talk to us about, are there planning options to allow you to qualify? All right. Now, after this, you will receive an automated phone call from us asking if you are interested in setting up an appointment. Again, the big thing is those appointments are going to be free. So whether you're a current client who just wants to make sure that you have a review done of your documents, whether you're a new client that we get to work with who already had an estate plan done, we can even review those documents to make sure they're up to date. Or if you are starting from square one and you want to get this journey started and get some more information, we would be absolutely thrilled to get to work with you. I'm going to hang out for a few minutes and just answer a few more questions as they come in, but thank you for spending some time with me today, and I look forward to working with each and every one of you. Okay, just had a great question about the healthcare. Must the doctor or hospital see the original to follow its instructions, or can a copy be suffice? So with our healthcare directives, a photocopy, so digital or just a hard copy, is as binding and valid as the original. So you can absolutely bring in a copy of it if it's one of ours and have them still accept it. In fact, with ours, we recommend that you actually put an electronic copy on file with the doctor so that they already have it. That was a great question. All right, I'm going to hang out for a few more minutes, and as I see if there's any other questions, I'll answer them. But other than that, I hope you all have a great rest of your Tuesday and great rest of your week. And I can't wait to get to work with you and look forward to seeing you. All right, another question came in. Can a family member be the decider for, I think it's incapacity, or does doctor have to be the one? So depending who you do your estate plan with can actually depend on the answer. If you do your estate plan with us, which obviously I hope you do, we generally have it as the doctor and at least one individual who knows you, and they end up working together. All right. I don't think I see any other questions at this point. So thank you all again for joining us. I hope that you found this helpful. We love getting to do these education events because not only does it allow you to hopefully learn something, but we love being able to connect with our clients and people who we have never had a chance to meet. So if I haven't gotten a chance to meet you, I hope I get to soon. And if we've already met, I hope I get to see you for a review in the not too distant future. Again, have a great rest of your day, and we look forward to hearing from you. Bye, everyone.